Good morning. Good morning. It is Thanksgiving week and court does not stop. It is only closed on Thursday. So we are here. It's November 26th and we are going live into court in Massachusetts because Karen Reed and her lawyers are back in court on discovery motions. So I feel like the only thing I should say is hear ye, hear ye, hear ye, law nerds of the chat. What, if anything, will be resolved in court today? Because the last time they were in court, it was a lot of let's come back another day. You know what the judge hasn't decided yet, though? If this case is getting continued from January, still no ruling on that. The Supreme Judicial Court has not ruled either. I'm going to roll the intro. We're going to roll right into court. When I had paused it, they had not started yet. They might be on the record, but if they are, it's only by a moment or two. Please forgive the under eye situation. I am both tired, and when I set my alarm, or at least when I thought I set my alarm, I was like, oh, court starts at 10 Eastern, Emily. Court starts at 10 Eastern. So did we oversleep a little bit? It's rare, but yes, we did. But guess what? My commute to court is within my house. So I am so much happier to be on this side than on that side trying to do court this week IRL. So glad to be here in my cozy Lawnerd 2.0 merch. I got all of the tattoos happening today. Happy to be here. Some of you are getting your Lawnerd Shop 2.0 merch today. Octo was letting me know that there are deliveries for today for some of you for the shop, which means some of you are going to see your gift with purchase, and I can't wait. So we're going to roll to court. I'm going to roll the intro. I'm going to see you soon. B2. Thank you for the gifted memberships because we do have fun Law Nerd member stuff happening this week. We'll talk about it in a moment. Let's roll the intro and then let's get into court, shall we?
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, law nerds, we are headed right into court and we'll see if they've started yet or if they're just puttering. So we'll let you know. Octo is like, I'm obsessed with who will be the first to see it. So you have to let me know. Yeah, you have to tag us all over social. And we used to play this game when I played water polo in Massachusetts. Every time we traveled with the team, we would actually take bets on whose luggage would come out of the luggage carrier first. So I feel like we're doing that again with Law Nerd Shop merch, where Octo's just like, who's going to be first? Anyway, the things you do, you know, pre-cell phone when traveling with a sports team. I feel like now they just make TikToks. So, you know, it's different, but cheers. I'm having coffee. Let me know where you're drinking. Hopefully in your mouth, what you're drinking and where you're coming in from as we get rolling into court. Yeah, Fred, we're watching court. Fred is sitting here watching my screen with court on it. So intent. So intent. That doesn't sound like it's coming through the right way. Hold on. Oh, that's on me. Give me 30 seconds. There we go. That sounds better. Hopefully, let me know if that sounds good to y'all. It sounds like a loud courtroom to me. These tables are so weird to me. So weird to me. Alexis says peppermint mint in Metro West Boston, wearing comfies and procrastinating cleaning the house. Look, the way I procrastinated things yesterday. I have peppermint mint in here today. It felt like the right thing to do. Big Sister said Ontario, Canada with Timmy's. That would be Tim Hortons French vanilla. EAAs in California, in OKC, and drinking my coffee while listening to my favorite YouTube channel. Well, thank you. Flattery will, in fact, get you everywhere. Water and Cape Cod, Massachusetts. The Cape is so lovely. I like the Cape this time of year when it's cold. I really do. I love a beach when it's cold. It's probably because I grew up in Southern California and there were days when the beach was cold, but not like Cape Cod beach cold. It was not the same. Do you guys hear well? Let me know. Are we hearing well? I'm going to put this on 2x because the sounds of just court are too much, are just too much. All of you say you can hear. Perfect. The occasional crackle. I don't love to hear that, but thank you. I can't tell if that's me or if that's court, because court has a lot of noise happening. But I am fascinated. I put this at 1.25. Fascinated as to what the lawyers are doing. I'm trying to gain down the background noise just so it's not... Here, I guess I can do it this way. Hold on. There we go. We'll just gain down court a little bit because, well... Do you think they decided to walk away from the camera? Do you think they heard the camera zoom in and go, no, we're walking to the other side of the courtroom? I would have. I absolutely would have. I think they're just chatting about stuff. Again, I have this sped up, so it's really hard to gauge the pleasantry of a conversation when I have this sped up. I think they're both sitting there. If it were me, I'd be sitting there going, is she really not going to continue this case from January? Are we really to believe that that's not going to happen? Are we really to sit here and believe that we're going to trial next month? Are we really? We don't want to go to trial next month. No one wants to go to trial this next month. What is happening? What is happening? I saw some of you ask in the chat, Muffin Man, what is this case about? We didn't do a summary at the top, so maybe we should do a quick summary now since we're waiting for court in Massachusetts. Let's do a real quick. Why not? Why not swoopy doop it and just do a real quick summary? I can do that. We're here. Might as well. Court's not in court yet. Let's swoop. For those of you that are like, Emily, what have we walked into? Karen Reed went to trial over the summer and, well, most of the summer, and the jury returned hung. She has been accused by the Commonwealth of striking her boyfriend, a Boston police officer, with her vehicle while intoxicated and leaving him there to die. The defense has said that she was set up, that she did not, in fact, hit him with her car, that she did not leave him there to die, and that he was actually killed inside the house where she was dropping him off. The jury came back hung. Since then, lots has happened. Members of the jury have come forward and said, well, we weren't hung on everything. We weren't hung on all of the counts. So can we give a verdict? That is being determined by the Supreme Judicial Court of Massachusetts. In this court, they are getting ready for the retrial in January. Both parties have asked that the case gets put over, not to January, but as they're chatting, I'm going to pull this back up, not to January, but to April. There is a new special prosecutor. They want to retest the, and the lawyers have left. They want to retest Karen Reed's Lexus. They want to do additional investigation. There is a federal investigation into this case. This is a woeful summary at this point because so much has happened. But the things that we do know for a fact, here are the facts that were proven at trial beyond a reasonable doubt. It was, in fact, snowing. Karen Reed drives a Lexus. Karen Reed and John O'Keefe, the victim, were in a relationship. They had traveled to Aruba. That the Waterfall Bar has high top tables and that everybody was at CF McCarthy. Not everybody. And that Karen Reed, John O'Keefe and his friends were at CF McCarthy's in advance of going to the Waterfall Bar, and they do not seem to have high tops, but they were sitting at the bar drinking. It was, let's see. So Karen Reed missed a turn to get to 34 Fairview. 34 Fairview is a house that exists, and the Alberts live there. What else do we know? What else do we know? One of the friends was drinking vodka and Crystal Light, and we were wondering if he brought his own Crystal Light to the party. One of the Alberts was turning 22, had a birthday party, and that's why everybody was going back to Fairview. Let's see. Brian Higgins did a lot of stuff with his phone that seems very odd. There were a ton of butt dials. Most people don't remember things. The Alberts had a dog and no longer have a dog. I don't know if, that was proven at trial. And the experts in biomechanics say that there is no evidence that the victim was hit by a car. Those things happened. So, yeah. They're still in court waiting for it to happen. So I'm going to zoom a little bit because we are behind time because I started late, but the court still hasn't come out. This is a lot of time that the court still hasn't come out. So let's see. Oh, we couldn't have timed that better. Oh, we're applauding that, and we're going to hear ye, and get into court. Since court's running a little late, we can just zoom. Let's hear ye. Let's go to court. All right.
Quiet, please.
Oh, damn it, Emily. Put it back to regular speed. You can't do a Boston accent at 1.25 speed. That is unacceptable. What in the world are you thinking? No. We're trying that again. Doodle-doo, doodle-doo.
Quiet, please. All persons having any business before the Honorable Federal Economic Justice in the Norfolk Superior Court and before the County of Norfolk. Your name, your examination shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
That courtroom's got some echo.
117, the Commonwealth versus Karen Reed. Can I come to identify themselves for the record?
Thank you, Mr. Clerk. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth.
Ooh,
along with
echo.
me, Adam Lally, and also Attorney Laura Moore.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCarthy.
Good morning, Your Honor. Elizabeth Little appearing on behalf of defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be in Zoom.
Okay, we can't see him though, Jim.
Alan Jackson is on Zoom. The sound is so bad. I'm going to gain it down a little bit to see if it helps with some of the distortion. But that's better.
Can't see you. Is that okay?
If the court audio is low, you guys are going to have to gain it up on your end, because otherwise we're not going to be able to hear
We
anything.
have several motions this morning. Let's
Yes.
start with motion for admission pro hoc vice that you filed. And Mr. Unetti, I know these.
The court said, God, it's just hard to hear. The court said this is the motion for admission pro hoc vice. That means admission for an attorney outside the jurisdiction. This was filed, last week? So let us see what the court has to say.
These are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Lassie has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Well, now we're going to find out exactly why they want to add another attorney. And we're going to hear an explanation. Now, Elizabeth in the chat said, is this a different courtroom? This is this judge's regular courtroom. The trial was moved into a different courtroom.
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level.
Ding,
He's
ding.
had many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of
That's fair.
labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
I just don't understand what you mean. He's an attorney who has specialized skills, Your Honor, which means he has skills that these attorneys need. She is paying for them. What? They're not asking for a continuance because of him.
Of this criminal nature, he has represented criminal defendants throughout his career.
Okay.
He's a criminal
All right,
attorney.
thank you. All right, so let's go on to the...
I can't roll my
discovery
eyes hard enough.
motions. We'll start with...
You're not even going to just say granted on the pro hoc vice? Not just like granted? It's going to be a long morning.
the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
What the court said is we are now going to get to the requested records of Mr. Reed. The prosecution has asked for cell phone records from Karen Reed's father. I believe this request came on the heels of of her interview, either with Vanity Fair or one of the other ones, where she was saying that she and her dad decided together that they needed to hire a lawyer. That's not admissible. So we'll see what they say. But I will say, though, I'm just like, pro hoc vices are normally just granted. It is nice to hear that this is why they're bringing in this attorney, expertise, trial lawyer, someone that Yannetti consults with. Great. Thank you for taking the microphone, sir.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe.
Right.
Second-degree murder, as the court is aware.
And it just says to me that at this point, you're still unclear how you're going to prove that. Maybe we don't go forward on that charge. It's like, no, I want to see if she texted her dad. If she texted her dad, it would have come back on all of her phone returns.
Is a person committing an intentional act with a strong, plain likelihood of death.
Mm-hmm.
In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to
knowledge
that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to their full value of their proof. The records for 30 days, to begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind.
Or she was leaving them voicemails exactly of the nature she left to John O'Keefe because she was drunk, and she said something to the effect of, he's with someone else, I'm fucking done, but okay.
The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period
around
from
that
Ms. Reed to her parents.
1 a.m. time period.
But can't you get that from Ms. Reed's phone?
No. No. There were 2 search warrants from Ms. Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants from Ms. Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay.
What he said was, we want the call log. So we want to show that there are no other calls in a 30-day period at 1 a.m., that this was an anomaly. And the defense is just going to go into court and say, yeah, she might have called her parents. And what the defense will do, probably to some effect, is line out when she made all those phone calls to John O'Keefe. A lot of those voicemails we heard. So if she's calling John O'Keefe, which is uncontroverted, she's calling John O'Keefe, screaming into his voicemail, thinking that he's cheating on her, pissed as hell and drunk. I imagine she was also at that point calling her parents and maybe others as well, because A, drunk, so time is a construct, and B, mad. But in all of those voicemails, I don't know. The Commonwealth's going to do what they're going to do. You know that I am not impressed with what they have shown for their evidence so far, because I just am not impressed with what they've shown for their evidence of knowledge so far, which is what he's arguing at this point. And I think the voicemails played were powerful evidence that she was mad, but also thought that that is a fight that was going to be resolved in the future. So we'll see, but they're asking for the call logs, and the judge is like, well, why can't you get this from Karen Reed's phone? He's about to explain why not.
And the other one is January.
And he said he said the search warrant was not too narrowly construed. They must be narrowly construed, CEG's tomorrow's podcast, but that the search warrant is limited in time, and they are looking for a larger period of time.
January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Ms. Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Ms. Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other
He's like,
calls,
I want to see.
It's terribly remarkable that she is panicked calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain,
Sir,
bleeding, so it would swell.
What?
Or they could have cracked his cranium.
Should have.
He would have suffered significant impairment. But I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first.
Did you hear him say, I expect the government is pursuing a witness? Sir, I know you're special counsel, but you're the government. You're the government right now. Are you talking about the defense? Or are you talking about yourself in the third person? I guess we'll find out.
First 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour
And y'all
phone
will
records,
see me. I am taking quite a bit of notes. Why? Because documents from Massachusetts are incredibly difficult to get. And so, to be able to go over later what is in these motions, I need notes. So you will see me taking notes. Let's continue.
will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial.
For all of you that are new to this case and are like, wow, this chat is really not so sympathetic to the prosecution at this point, the last trial is why. I go into every case with as much of an open mind as I can, and if I can't, I tell you why. But with this, I went into this trial hoping that there would be some answers here, and there were not. So yes, I'm not tremendously sympathetic at this point because we've already seen an entire trial. I'm also of the frame of mind that the government should not have enhanced the charges based on the evidence that they've put forward, and I have some fairly strong feelings about that at this point. So we will continue to see. Look, I'm interested to see what his theory is. A lot of you have asked the question, can the government expand their theory or shift their theory on a retrial? They can. They can shift their theory. But again, my focus on this case is what questions is the Commonwealth answering? And so far, still not a lot. So for all of you that are like, I'm new to this case, yes, we had a very long, 9 weeks of trial in this case. And when I say it felt like 137 years of trial, it's because it felt like 137 years of trial with the former prosecutor. However, Brennan has not said what, if anything, yet. And to that, I appreciate it. Johnny's girl, no, I am not biased for Karen Reed. At this point, the government has not proven their case well at all. At all. And I never want to see the government overreach. It's not what they should be doing as prosecutors. I want to see them do their job well. So no, the government has not changed my mind. They have not changed my mind. They had an entire trial to change my mind, and they did not change my mind from innocent until proven. The government has not moved that needle for me with their case. So let's continue.
Phone calls to Ms. Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show
the judge might allow
different
this.
Communications. Sometimes calls or hang-ups don't register on a phone. And so they could be different.
In the call record.
Secondly, I've learned that Ms. Reed's phone was sent to a taint team. And the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps...
Ask the law enforcement officers why it went to a taint team.
The defense raised the issue. I don't have the benefit of the history. But what I do know...
We
is
do. We
cannot
watched
say
it
that
happen
the
at trial.
records from Ms. Reed are a full accounting of her records. And so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited.
It is pretty limited.
I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference,
The narrowness
it's a sound
might be
inference,
why-
it's a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
He's easier to
Who's
follow.
arguing this for the defense?
I am not necessarily persuaded by his argument, but he is much easier to follow, and for that I am thankful. We're going to look for a silver lining, but he is much easier to follow, and for that I'm thankful. His request is pretty narrow, and the court might allow it. He is saying, I want call logs of a 30-day period for any call between Karen Reed's phone number and her father's phone number, and then I want the call logs for like the 24-hour period surrounding John O'Keefe's death in that period. So I want to see both. So let's see.
Defense.
Thank you, Your Honor.
Oh, and there's a great question in the chat. Is there a privilege for parent-child like a spousal privilege? No, there is not.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone.
Are you saying it's a fishing expedition? Say it's a fishing
His private subscriber
expedition.
information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter.
Some of that did open up because
But
he
the
went on
Commonwealth
the
already
media,
has
right?
a record of all of the communications between Mr. Reed and his daughter
From
on
Karen's
January
phone.
29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't
Right.
prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's.
But he
and
heard
wasn't
statements
present
from
at
the
Waterfall
defendant.
on January 29th, 2022.
And that's the problem.
And I would note that this court has repeatedly
The problem is, if, and I don't know what he said on the news or not, but if he went on the news and said he had conversations with Karen Reed and she said, I hit something, that is incredibly relevant. I can see the court allowing this.
emphasized the importance of privacy concerns when it comes to an individual.
I love a pointer finger ring, just as an aside.
Using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
Ooh, hold on. I'm going to back that up. I got distracted by her ring. This is a very fair argument. We're going to run that back again because she is saying that the logic that the court used to deny defense requests for records should apply here, using the court's previous rulings to say we need to have some consistency. So I'm going to back up as she argues that
January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
it's a strong argument.
The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn.
But that wouldn't be
And
a
I've attached
1:30
a copy
call.
of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m.
So there wasn't a 1 a.m. call? She's saying no. There wasn't a call until 6:30. If I can also see the court saying if there's a discrepancy between when there was or was not a call, we need the other call records.
The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test.
The rules.
In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon.
They say it wasn't answered like so many of the calls in this
The Commonwealth is well aware of
case.
that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m.
Interesting.
So the frequency at which Ms. Reed called her father's cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron.
She's doing a good job walking through the case law.
Affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its
There's the
affidavit,
fishing expedition.
Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate
Well, they didn't
use of
ask
Rule
for that,
17.
they're
This
saying.
unsupported request is overbroad and must be denied.
I want to know about the difference in the time.
All right, thank you.
I
Do
wa-
you
I-
want to respond in any way, Mr. Brennan, or move on?
I want to know about the difference of the calls. The prosecution is saying that Karen Reed, called both of her parents around 1:30 in the morning. But the defense is saying, no, the phone records show that there was one call at 6:30 a.m. So where are the 1:30 calls? And then the case that they're citing sets out the factors for the Rule 17B motion, and the defense walked through those factors and said the prosecution's motion fails on these factors. The court said, prosecution, would you like to respond or shall we move on?
Very briefly.
Very briefly is the answer, so let's see what we think.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't.
And that's why
And
we're
so,
asking for the records, right?
We have to prepare that when Mr. Reed
Right.
takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent at trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All
Interesting.
right, did you want to respond at all, Ms. Little?
She might allow that.
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone.
And
All I'm
of course
saying
they
is
don't.
that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but Ms. Little.
So what the court just said is we've heard your records as to the father. Do you want us to hear further argument about Janet Reed's phone, or is it same? And the prosecution is saying same unless you have any questions for me.
Thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of their request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land prime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land prime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay. Thank you.
So what she said to the court was, this is not discretionary. This is not within the court's discretion. If you do not meet the 4 prongs, not prawns, chat, I see you. Everybody's like seafood. Massachusetts, seafood. If you do not meet the 4 prongs of land prawn, fair enough, then it is not discretionary. You must deny this motion. Remember, this motion will have 2 steps, right? Whether or not the prosecution gets the discovery, and then if they get the discovery, which the defense is vehemently against, if the court gives them the discovery, there is still another fight over whether or not that can be used at trial. But what we've learned is that the Commonwealth very much intends to call Karen Read's parents to ask them about the conversations they had with Karen Read. No, that is not hearsay when it goes to Karen Read's own statements. So that is what they are trying to get to. We did not see them called in the first trial, and it seems like we will see Karen Read's parents called in the second trial, which could backfire horribly for the prosecution or not, depending on what they say. It could make Karen Read look very empathetic. Remember, her father's the one that called for the section, do they call it section 12 in Massachusetts, for the psych hold. He was concerned. He was scared for her. That could make him look very empathetic to a jury. So let's continue on. So those are 2 motions. He does not look happy.
So we will move along now. Both of those are under advisement. We'll move along now.
Next motion.
It's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Corp. I do have an opposition that I received this morning. And an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So
this is a motion for all, and the court listed it out, recordings, notes, audio from Gretchen Voss regarding an interview Karen Read did. They haven't gone after Vanity Fair yet, but they might go after Vanity Fair soon. So let us see what this argument is about Gretchen Voss. But the Commonwealth wants all of the things that Karen Read talked about, and so far they've only gotten redacted portions of that. I went over those motions, and things were redacted out from the notes that were given to the prosecution.
Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
The Commonwealth has filed a motion to reconsider in part, and in addition, there is a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Read publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And
There's
after
Vanity
review of
Fair.
all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours
And I've covered
long.
some of this.
The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times.
So all three attorneys were present.
And so there are significant
when that interview was given.
And redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements.
I think some of that's a fair argument.
Directly on the credibility of the witness.
I think some of that's a fair argument, and here's why. Jennifer Baker said in the chat, they shouldn't hear what the attorneys said. There's no privilege here because it's not conversations between Karen Reed and her attorneys. It is a conversation between Karen Reed, her attorneys, and Gretchen Voss from Boston Magazine. The presence of the third person means that none of this is privileged. When I say media interviews are dangerous and potentially tenuous, I think the court is going to allow some of this. But no, what her attorneys said and Karen Reed changing her statement is generally subject to discovery because of the third party being there. So they are trying to get to all of the information from the Boston Magazine interview, not just what was recorded, not just what was put out into the media, but everything that was said. So even if Aaron says, unless it was explicitly off the record, even if it's explicitly off the record, the prosecution has the right to seek it. The media can push back and say, no, that falls under our own privilege. And we've got a lawyer from Boston Magazine or who works with Boston Magazine present in court who's going to argue on behalf of the media, arguing their rights to talk to sources, arguing that they are protected. I don't know what the media shield laws look like in Massachusetts, but these become shield laws of, no, we're the media. We don't have to turn over everything. I don't give a fuck if you want it or not, but it's not our obligation to turn it over to you. So this is dealing with a separate set of rights, not just Karen Reed's, but also Boston Magazine and what they have to turn over or not, because they redacted it. So no attorney-client privilege, but there might be laws in Massachusetts that protect Boston Magazine. So we're going to see the rights here are going to bump up against each other. And some of you are saying, unless the reporter left the room. If the reporter left the room, Katrina Bunny, I think we would hear about that from the defense, but also then there shouldn't be a tape player from Boston Magazine still recording. So we'll see what goes on, and I'm interested to hear what happens. But planned media interviews with your lawyers can be dangerous, and this is part of the danger. And I think of any of these motions that we've heard so far, the court is going to be most inclined to turn all this over. And let's see. Emma is saying there are no shield laws in Massachusetts. Well, that's going to make it a little harder for the media to argue then, isn't it? Look, that's going to be a problem. Thank you, Chat. See, Chat is the best research attorney ever. Chat is like, oh, no. Massachusetts, really? No laws? Oh, we're going to have to talk about that later.
Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of a defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussion.
I will say, and then I'm going to stop pausing this one so much and just take notes. It's even wilder to me that the defense would agree to these interviews knowing that anything that's said can be compelled, knowing that there's no shield laws. That's really wild to me. So again, that's the landscape they would have been agreeing to. But I think the defense here was incredibly confident that they wouldn't be facing a retrial because she would be acquitted. And I think the Commonwealth at times was overconfident in their case and did not explain it well at all. But okay.
Questions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected.
None of that's privileged.
Is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where
I am more empathetic to his argument here, for sure.
To understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses.
They chose to do that.
Substantive statement.
Oh boy.
Many of them admissions of guilt, contradictions.
They're all witnesses. They're all witnesses, Your Honor.
The most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now,
isn't it Elizabeth Voss? No, Gretchen Voss? Isn't it Gretchen Voss? Sir, look, I don't know why Emily's on your mind, but respectfully, my name, no. I thought it was Gretchen Voss. Either way, he makes a good point. And the interesting point he is making is that, look, going after the attorneys to get this information is really heavy-handed. So we need the information from the reporter, Your Honor. There's no reason to redact all of this. she might give him this unredacted. We'll see. But is he going to try to call Gretchen Voss to the stand? Probably. Why? Because Karen Reed admits to drinking, if nothing else, to Gretchen Voss, admits to drinking. And one of the questions in the first trial is, how do we know she was drinking alcohol? How do we know she was drinking those drinks? The Commonwealth went through, see, she was drinking all these drinks. And people are like, how do we know she wasn't just ordering like seltzer water or whatever? So it will head off some of those arguments.
In the pleadings, I received the response this morning. I didn't get to read the
Ms.
entire thing. I
JMD,
have
thank
no
you.
objection to it.
It's all about me, though.
But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that never even may not be used at trial anyway.
And that's
because
different.
It's based on hearsay or there's no factual basis for it.
Okay.
This is not a confidential informant.
Right. That's
The
a very
defense
different
chose
situation to talk to a reporter.
very strategic strategy to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants.
And we can use them
But
against
when
him.
she does, there is a consequence for that.
Look, there are times in court when Karen Reed's face speaks very loudly, and we're going to see, well, you will see me talking about this in tomorrow's podcast about what statements a defendant is allowed to make because it's being argued very heavily in the Diddy case. But the DA is like, right, she is presumed innocent. She's allowed to make statements, but we're allowed to use them. And her look was like, sir, I keep trying to tell y'all that. This case, man, this case. So, yes, that was a very strong look. But I think of the arguments we've seen this attorney make so far, this one is easy to follow, and he might win on this.
And they now bear the consequence of these statements that have been made. And so,
Yeah.
since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize.
Right.
In this case, firsthand, I have never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines
I agree with
the
that.
fabric of the judicial system.
It is repugnant.
But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case, she is in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case.
Who's going after Gretchen
doesn't.
Voss?
And so
She did an interview.
there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest.
Chat, yes, it's not
But
lost.
cover up what
It's not
doesn't.
lost on me that he has been an attorney for the mob. So, yeah, it's not lost on me, his argument. However, this case has gotten wild with that, and fear of the witness is not going to be sufficient here, even though it is uncomfortable, but at least he's easy to follow.
The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no
So
exception.
crucial and damning it wasn't. Wait, when was the Boston Globe
All right,
interview?
Thank you. Mr. Birch.
I can't say that. I don't know if this was before or after the first trial. I really don't remember the date on when that interview was. Mr. Birch is going to be the attorney for, for the publication, not specifically for Gretchen Voss, but for the publication to come in and argue that in the publication, they have a right. So that is who's going to argue now, not the defense in this case, because this is now between Gretchen Voss, Boston Globe, and the prosecution. The court might grant this. Was this before the trial? The chat is saying this was an interview before the trial. I'm surprised they didn't use it at the first trial then to at least tie down Karen Reed saying, yes, I was drinking. It is one piece of the puzzle. Does it change the entirety of the case? No, but it answers one question. And what the Commonwealth needs to do in this case is answer all of the questions. I don't know if they'll be able to on a retrial, but they need to be able to answer all of the questions in this case. And at least answering a few would help. Nobody asked if they were high tops or not. That's not a question we needed answered.
Thank you, Your Honor. Robert.
They answered it.
For
I knew that.
Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor, at that time, made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made...
The video froze a little bit, but what we've learned from the Boston Globe attorney is that this 17B motion already came up, and the court said conversations with the attorneys, if she was basing that on privilege, she's probably wrong, but conversations with the attorneys are to be redacted out, and off-the-record conversations are to be redacted out. But I don't think that is I don't know what law she based that on. However, that's what the court decided to do. And so they're like, look, Your Honor, you already did this. Can you just do the same thing again?
No persuasive
But the video
showing
in court is
as to
frozen.
why the decision should be any different now. The Commonwealth
Hopefully it'll unfreeze itself,
makes much of the fact that
because this is
there are
just
heavy
a
redactions
rude
on-
freezing. Hold on, let me see. Let me see if it unfreezes itself. If I jump forward and then jump backwards, we're gonna go. Nope. It is just their feet is frozen. All right, we're just gonna have to live.
The fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did
Lally.
not want colloquy of attorneys. It did not seek what the attorney.
Well, that's on Lally.
And it said that over
He should
and
have.
over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back even at the first trial?
Oh,
To come back and request it upon review of the first?
the video feed is freezing. The attorney for the Boston Globe is speaking and the video is freezing. At least we have audio. But Emily, back up your brain. I now hear just the beeping sound. The ADHD is always a joy. But what the attorney for the Boston Globe is saying is, look, the first time the Commonwealth asked, they narrowed down their ask. That was Lally. And he's saying, so the court's already done this. And the court is saying, didn't I leave this open for them to come back and ask for more? And that's the answer here.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now.
Yeah, that's
a
going to
new
get granted.
trial. We have different attorneys presumed with today's motion on both sides.
Yep.
So
Yep. She's
why are
going to
we
probably grant
focusing
this.
on what they requested first? And what's different than now?
She's not happy.
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is,
She's
why
saying
they
it's a new
need that
trial.
More. They had made a determination at one
Well,
time.
counsel, the court just said a whole new world. The court's like, it's a new trial. Don't talk to me about what we did at the first trial. We got a whole new trial up in this bitch. So let's go. The court's probably going to grant this based on her statements there. That's what I
In order to be
would guess.
fully prepared for trial, they only needed a certain amount. And they only needed the.
Well, now they want more. New
attorney's
lawyer, new
colloquy.
tactics.
And now they're saying the attorney's colloquy is central to what they need.
New lawyer.
And, they can't have it both ways.
Yeah, they can. They absolutely can. It's a new trial. They can ask for more. Lally unnecessarily limited the scope of what he was asking for, but that doesn't mean that the new prosecutor has to do the same. So I'm not surprised on that.
Okay, go ahead.
The change of subject.
Counsel, you're going to have to argue that better.
Before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that
Well, it's not really for you to decide that.
has the impact of serving as grist for impeachment at trial.
That's not for impeachment at trial. Oh, he's arguing not as clearly against the prosecution. And the prosecution said, if Gretchen Voss is up on the stand, I can say, what did Karen Reed say? Then did she talk to her lawyers? And then what did she say? So it can show that Karen Reed's story was changing throughout the course of the interview. And if they don't have all of the interview and Gretchen Voss says something that's not what's in the transcripts, then Gretchen Voss can be impeached on that and questioned further on that. And the prosecution can't do that if they don't have the entirety of the transcripts. So I think that's what we're getting to with this. Look, man, doing media interviews is a dicey thing when you are pending trial.
And one has to wonder whether this.
Oh, thanks, Chris.
Vote
Boston
is
Magazine.
really,
I've used it interchangeably with Boston
an
Globe.
effort
Apologies.
to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment.
And this is the hard
endangering
thing.
The safety of herself and her family.
If Gretchen Voss is operating in a state that does not have any type of shield laws for reporters, then yeah, it puts her in a very tough position. And it puts her publication in a very tough position, because then the position they're in, if the court grants this, the choice is then to deny or to flout the court order and say, fine, I'm not turning it over. Hold me in contempt. Fine my publication. Put me in jail. But Gretchen Voss can't really necessarily make that determination on her own, because there's still a corporate entity that's going to make that decision. And yes, that would make it harder for her as a reporter. Why Massachusetts doesn't have those laws, I have no idea. But it's got to be difficult for the publication too. So we'll see.
And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case and her fears for her own safety.
Well, that's not a reason to not turn it over.
No doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corporation's counsel undertook time and expense to redact them to accord with.
None of this goes to your legal argument, though.
As approved, what the subpoena as issued had asked for. They're asking now for
all of it. No time and expense.
Handwritten notes of Ms. Voss.
No redactions.
A one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape.
Okay.
They are partial notes. They are
protected how?
Phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview, if forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her.
Yep,
or
probably.
call her a trial.
Yep, probably.
In order to explain those notes.
Yep,
and
probably.
interpret them. And that's going to take us down yet one more rabbit hole.
What hole is that?
In this case, I've just already had so many.
That's a fact.
It would also have the effect.
Can you go
maybe
back and explain the rabbit hole?
effect of preventing Ms. Voss from covering the trial.
Yes, it would.
Because if she is called as a witness,
She'll be excluded.
Not permitted to sit in and
Yep.
courtroom for the proceedings.
Yep.
So she did attend the last trial, right?
She did
On a
because she
daily
was not on
basis.
the witness list.
Right, on a daily basis?
Mm-hmm.
I believe so, yes.
Okay,
Every day? Yes.
okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Okay, thank you.
That was loud.
And finally, the Commonwealth asks for the first time, for texts between
I don't know if she'll be prevented from covering it.
Ms. Voss. And we do have texts.
They could agree that she could still be there.
The manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask her we're willing to turn those over. They were not off the record. But I asked that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay.
And that's all I have, Your Honor.
All right. Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
So the court,
Okay.
in the hearings that I have watched, which has been the trial and then the post-trial litigation, this is the most I've seen the judge really ask questions of the attorneys. I appreciate it because we can see at least where or what the court is thinking about. So I'm curious to see what questions she has for the Commonwealth from the opposition.
So what I'm going to ask you to respond to is on page 5. First full paragraph. The paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
That is not, having received this morning, we knew these motions were on for today as of the last court hearing, and now counsel for the Commonwealth is reviewing the opposition. The court reiterated what she specifically wants the Commonwealth to respond to, and the court essentially was insinuating that, no, not insinuating, the court was reading the opposition that said, essentially, this is a fishing expedition, and the Commonwealth...
This posits two separate ideas, the way...
The Commonwealth wants more information because the goods weren't in the... the goods weren't in the non-redacted part, is what they're saying.
I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes. But at one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The story...
I am not tremendously empathetic to this argument if we are discussing the side door versus the front door from the 2 doors that are facing the street on the house. Because there are 2 doors in the front. Counsel, I'm not... okay.
And the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so... I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, We're entitled to take her statements with Ms. Voss and compare them to all the other statements she made.
And she doesn't have to be truthful with Ms.
2020,
Voss.
Vanity Fair, Dateline, and others.
She gave a lot
And
of
so
statements.
the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further
The waterfall bar,
drinking.
not like on a hike.
And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed
And I don't know if
the
it's
admission of
incredulous.
drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. In representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and
I think they're going to get it
pursue
in this
We're entitled to
motion.
all of these records, all this information. There is no legal argument against it, none.
I think they're going to get
All
the
right.
full interviews.
Thank you.
Again-
So I know, Ms. Little, I asked if you
Again, this is part 1, right? Part 1, these are the discovery motions. Give us the stuff. The next part is what will be admissible or not. Those are two completely separate arguments. Right now, we're only talking about what the Commonwealth may be given from Boston Magazine. I think I used Boston Magazine and Boston Globe interchangeably earlier. Apologies, from that Gretchen Voss interview. And I wonder what we will see about the others, or if not. But the way this is going, I think we might see the court deny this continuation motion and keep pushing these parties to trial, which is going to be wild to me. But let's see.
wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? Okay. All right.
Which
so
is
that
fair. The
is-
court offered the defense an opportunity to be heard. It is not their motion. This is not their fight. This is between the media outlet and the prosecution. Moving on to our next motion.
Taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so, Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all three, but do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the three? There are three motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston.
So three more media arguments.
And again, on these, Ms. Little, you don't expect to argue? No, you're right. Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will.
So these are three motions. The same attorney is arguing for a variety of media outlets. So they're going to lump all three of these together, arguing essentially for what we're going to see or what we just heard with regard to the Gretchen Voss interview for other media outlets. For all of you asking about, isn't this hearsay? Not when they're statements of Karen Reed. Those are statements of a party opponent. Sometimes they're statements against interest. The prosecution saying they're admissions. So we're going to continue on with these motions.
We'll hear you. Why don't we start with the FXT TV, Boston 25. It's paper number 400.
So we're starting with Boston 25.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
He
Then
did.
I misspoke.
He did say that.
My apologies. Did
He
she
did
believe
misspeak.
she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is, by inference, in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit, supposedly now, another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been
So they want all of the
provided.
video.
During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all of his statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context some of the doctrine of completeness. We should know what the entirety of the conversation interview was so that we can assess this statement and draw the proper inferences from it.
It's going to be a
It's
harder
expected that
fight
William Reed very likely will be a witness at trial.
to get the dads.
He will be asked about
Interview.
this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or corroboration, that both sides are aware and know of the substance of that material. And that is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
So the unaired footage.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we can
Sure.
streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10,
It sounds like they agreed to give over the promo
position
materials.
is that
I don't know what's in there that's going to help.
one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand mail, UPS, to a number of subsidiaries. I don't think we're satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment.
Right.
It's, I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10?
NBC 10,
Here, just, you know what, Jim, you can give it
which is
to
where
me
we're
after I
watching
don't
this
have that
feed,
paper number
because
or the other one. All right, so do you want to move?
427. Your
they
Honor.
have closed
What do
captioning.
427? All right, so do you want to move on to CVB TV?
So
Yes.
they were looking for promotional materials from NBC 10, and now we're going on to
WCVB TV
WCVB
has been
TV.
served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position
Is we've
relative
served the
to
parent company.
ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business here. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice.
Oh my God, we know.
Objections, and to provide materials.
But you
It
served
is
the
done
registered agent.
routinely in civil cases when a registered agent is notified, they are then obligated to get materials even if the REM exists in a different place.
Yeah.
Their
Okay.
position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being in another jurisdiction is not in the control or purview of the local registered agent would just be
Doesn't
enacting
matter.
a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That, I don't believe, is how the law is set up. As a registered agent, they are the same as the company. They just have a local
Are they objecting?
contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that 5th paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you one, the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired on 2020 and Nightline, you hear oftentimes the author of the story, not even the interviewer, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview.
There is a lot of that.
The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach
Yeah, we know that.
Ms. Reed should she testify. It is hearsay. It's inadmissible.
Yeah, we know.
And so these summaries
You
have
focus
a
on her
genesis
statements?
somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not similar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant, which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect
The raw
it.
footage.
We should have the opportunity to.
We've seen this
review
argued in a
all
lot of the Bravo
statements and also
cases
put
as
the
well,
ones in
right?
context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look
Sure.
at the response.
Okay.
I'm sure you're going to hear some of it right now.
Mr. Albano, we'll give him a couple of minutes just to read it.
Oh, good.
Sure.
Great. Zoom. Zoomy zoom. Zoom, 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 zoom.
Jim, does this have a docket number yet? Paragraph 5, it's on page 3. The pages aren't numbered. Actually, you should start at 4. Or why don't you read the whole thing, Mr. Ray? Why don't you
Just
have a
let him
seat
read
and
the
it?
entire thing.
Okay.
Nothing is more stressful than trying to read while people are waiting on you, but the objection was filed, it seems like, before court this morning. So I'm going to zoom while counsel reads. It seems that we have time to do so. All right. Have we adequately zoomed? counsel?
May I?
Sure.
I think
Thank you.
so. Commonwealth is
Your Honor,
continuing
our
their.
position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York
Right.
that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and jeopardize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not...
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material, so that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Thank you,
Interesting.
Your Honor. The two cases I cited, just to be clear, they address the uniform.
Counsel is representing multiple media outlets, including ABC. So there were different arguments regarding the different media outlets. The argument at the end with regard to ABC is that ABC has said in their opposition, look, I know you would love the unaired footage from the 2020 interview that I think was also part of that interview used on, what did they say, on Nightline. We know you would love that, but you are trying to subpoena an out-of-state witness. And you can't do that. If you would like this material, you can, welcome to New York, and you can come up here and try to get it. And New York courts are going to apply a different standard because there are shield laws for the media in New York that don't exist in Massachusetts, as the prosecutor just said. So the prosecutor said, no, there is a registered agent for ABC here in Massachusetts. We have served that registered agent, and now they are obligated to provide the materials that we are seeking. We do not need a witness. We need the unaired parts of the interview turned over to us from Karen Reed's 2020 interview if there was just one interview that was then spliced down from multiple shows. So they're saying, no, we don't want to go to New York. We know why they want to go to New York. It's better for them if we do. We want them to turn it over here. We're in Massachusetts. They're not going to get to quash the subpoena to the registered agent. The registered agent is in Massachusetts. They have a presence in Massachusetts, so they need to be served here. So there are a couple different arguments legally going on with where service is proper and whether the subpoena can be quashed or not. And then they are also arguing with regard to other outlets, though it seems like with NBC 10, it's all been agreed that the promo materials will be turned over. WCVB said, go get the parent company. And they said, fine, we'll go do that. And then with regard to Boston 25, there's going to be some more argument there. So Boston 25 goes to Karen Reed's father talking to Boston 25, which is different legally than Karen Reed speaking, where the ABC argument goes to Karen Reed speaking. So we're really dealing with 4 motions narrowed down to 2.
Reform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now,
legally foreign just means not in the state of
Massachusetts. Okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them through their registered agent. But that wouldn't change the domicile or citizenship of ABC if there were a diverse.
Whoever is operating the camera, I know that the audience seems very interesting to you. However, these are actually really interesting legal arguments about whether or not the registered agent of a corporation can be served in a request and subpoena for documents, not just in a request for lawsuit. So can we please go back to the media? These are actually really interesting. I know they're kind of nuanced legal arguments, but these are really interesting legal arguments where they're saying, no, if you need to sue someone in a state, you can notice their registered agent. But if you need to subpoena them, you need to go to their headquarters in Massachusetts or in New York. So go to New York. I know you don't want to do that because you're going to lose the motion in New York, but go there. So can we just go back to the lawyer? This is actually really interesting.
Plaintiff and a diverse defendant, it would still be removable. It doesn't make them residents of Massachusetts or, for example, subject to taxes in Massachusetts.
Lawyer.
It's simply a way to make service of process, but the plain language of the Uniform Act and the policy underlying it is not overridden by service. The two cases that I did cite, one is the grand jury case out of I think it started in Rhode Island, SJC case, and that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether
New York tells you to fuck off.
The
Right.
second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues us an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York
Control. What's the choice of law?
Is that privilege dispositive? And that's what we say is the right
Can we
answer
just
here.
go back to the lawyer?
Yeah, they have a point. They can make service, but it doesn't override the statutory requirements of the Uniform Act.
To the lawyer?
And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out. Fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here.
Excuse me.
Does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that,
Lawyer.
yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over
camera work.
Published information,
Okay.
not unpublished information, but I do think that, so I think WBTS and WFXT are
Handled.
effectively resolved.
Great. The ABC fight's going to
Do
be
you
a
want to
fight.
respond, Mr. Moran? Thank you, Mr. Albino.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts,
That's different.
and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law. Because the company operates also in Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here.
Different.
Because they have a registered agent here. It does not matter.
Did the interview take place in Massachusetts or did the interview take place in New York, though?
Any follow-up, Mr. Albano? Sure.
Can we just focus on the lawyers that are making the arguments?
My first point is that we're dealing with a statute here, and the statute says this is how it works when you have an out-of-state witness in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCVB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC News programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
If the SJC said that, that'll be controlling.
All right, thank you. So those are all the Rule 17 motions we have. Am I missing anything? Those are all the Rule 17 motions. Right?
Thank you.
All right, so we have some housekeeping matters that I just wanted to check on.
All right. So we're going to move on to housekeeping. Here's, as all of you who are watching, probably like me, were distracted by the wide and swift panning camera work versus getting to focus on the attorneys while they are speaking, because it is difficult sometimes to pay attention when you are not seeing the person that is speaking. The attorney representing the media companies at the end said, the Supreme Judicial Court has said that the statutory procedure for bringing in out-of-state witnesses is the same for bringing in out-of-state documents or other evidence, and that is what's controlling, and this procedure is not being followed. It's not different. And you heard the prosecution citing to tort law. What the prosecution didn't say is the courts in Massachusetts have held this statute allows us to do this. That's probably because it does not allow them to do what they're trying to do. What the prosecution is trying to do is to get ABC to give it all the unaired footage of the 2020 interview, or the interview that was used in 2020 and Nightline and what have you. The thing is, in New York, ABC is going to be in a much better position to oppose any such subpoena because they have different laws. So if you have to go to New York to try to get this stuff, it's probably not going to go very, very far. So let's get into the housekeeping matters from the court.
Still have the motion to continue under advisement. I need to see how we progress for that.
Your Honor, it's so rude. It's just so rude to still have the motion to continue under advisement, which indicates to me that she's at least considering denying it, which she has done before, because otherwise, why wouldn't you just grant it? So when both the attorneys are like, we need to continue, the court's like, maybe not, maybe not. So that's still under advisement.
Matters that I just wanted to check on. I still have the motion to continue under advisement. I need to see how we progress for that. The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that? Mr. Brennan.
This is regarding the testing of the Lexus SUV. So maybe the court, when she's saying, I want to know how we are progressing on discovery before I just kick it out, then we'll go forward.
I know you had said you told them that, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they are going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called a chip-on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car, because there's different software which will give it even a more fulsome reading. And so after the December
We always love a
5th
use of
event is
fulsome.
done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this, the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had sort of like a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a
Yikes.
week after the November 13th date.
Okay.
Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
He's on
Your Honor, Ms.
Zoom.
Little addressed the court's specific question about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you.
Apparently,
All right,
Mr. Jackson
that is it for today. The Commonwealth
is via robot, but he was saying, essentially, it sounded like he was saying that's inaccurate, that it's going to take the reporters about 6 weeks from the week after the last hearing to get the sidebars. Remember, the sidebars are impounded, e.g. sealed, so we will not see those, but they are getting all of the sidebar conferences for all of the parties.
is going to file a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll
Okay.
file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I expended many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I've produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right. There are a couple of issues related to this motion, in addition to the protective order, that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
All right, I haven't read this yet, so I won't know what you're talking about, Mr. Newman.
So I believe you have read our motion, right? The motion that
I read your motion, I haven't.
Right. So it's just in relation to
He's
the
like, can we
motion
just
All right.
get it done now? We're all here. Can we just get it done, please?
Your Honor, generally speaking, we do not have an objection to a
So on housekeeping, they're circling back to some of the discovery motions. That's what they are talking about now. So they are keeping the court up to date with the things that are ongoing. And the defense said, no, we actually have a few things that we need to address regarding that. And that's what they're doing now.
protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here, or was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan provided this to us this morning.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared
with the defense team,
including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense
objection
team?
to the parties they would like to share it with, and I understand this without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done,
representations,
trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion.
They
But
do seem to be working well
raise an issue for
enough
the court.
together.
Actually, two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the.
For those of you like, what have we tread into now? We have tread into now the defense request to get to the elected DA Morrissey's communications. And that is what is being tread into at the moment. No wonder the defense was like, might I have a moment, Your Honor? Because we are trying to get to the elected DA's communications regarding this case. We're going to back up and start over with regard to the defense discovery motion regarding the district attorney's potential use of a personal email address for business related, which can open up the entire thing to potential discovery or request. And that's what we are getting into now. So the defense is like, Your Honor, one more thing, we promise.
General objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously raises some questions for us.
What?
Maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text.
So the defense is saying that the Commonwealth has gone through Morrissey's work phone text messages. I don't think he's talking about personal as well, saying that his text messages are set to auto-delete every 30 days. I believe that is a setting in iPhone. I don't know about Androids. I'm sure the chat knows more, but you can set it in your cell phone to have your messages auto-delete. That doesn't necessarily mean they are gone off of the cell phone provider. And I think what the defense is probably going to ask for at some point then is, well, now we need an extraction of the phone to determine when that setting was changed or if that setting has always been there.
Text messages from 30 days prior. So, through today, I believe.
They were preserved, Mr. Brennan?
I've been preserving them since I started the task last week.
Okay, so they're now being preserved.
All right, so that...
Yes, that deals with that issue.
Okay.
So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan ordered conducted or conducted himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed, R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name, but we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of,
That might be too broad.
is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same
That's
reason,
fair.
both at Stoughton District Court where this case originated, and
But wouldn't clerk's office employees have the same suffix on their email address? Like on the at whatever the ending is. But I think part of the thing the defense is getting to is, right, but what if somebody else sent the email? What if he sent somebody an email and said, you send this email? At what point does that all need to be evaluated? I think my preference would be send it all to an independent discovery mediator and let a discovery mediator go through it. I don't think this prosecutor has time to thoroughly go through it, but send it to a discovery mediator to go through it and then decide what gets turned over. A discovery mediator, by the way, outside of the district attorney's office, just send it out and let somebody else scour through it and see what happens. So I think that would be the only thing that would be, well, we'll see what the court does, but I think that would be the easiest way to solve it.
this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email
a special
master communication, and we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the DOCKET hearing.
That's fair enough. Thank you, Your
Does
Honor.
that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion, and I'll continue to do that. If they want to discuss how I can accommodate them, I'll do my best.
Okay. All right.
Okay, the judge said continue working on it and we'll talk about it if we need to talk about it on December 12th.
So we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the DOCKET hearing?
Yeah.
Yes.
Your Honor, we drafted a landing and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to
Happy
be here
Thanksgiving,
at the end of
attorneys.
the
You're all
week,
going to be
so that's
working.
great. And your response by next week, Ms. Giannetti?
It's going to have to be. So the Daubert hearing is for December 12th. That's regarding the experts and how experty they are, to put it in layman's terms. Everyone's going to be working quite a lot.
Yes, if we could have it at least a week, Your Honor.
Okay. So I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Ms. Giannetti?
With that exception.
I expect I will, without prejudice.
I have the materials. I'll just wait. to make a
Okay.
decision.
All right. So if you sign it, then I'll endorse it, Ms. Giannetti. You had it, right? Ms. Little gave it to us just now?
I believe we just gave our copy to the court.
Yes.
All right. So this is the one that needs to be signed, and I'll endorse it. Do you want to take a look at it?
Yes.
All right. We're going to get to Q&A in just a minute. They're wrapping up in court. We'll be back in court on December 12th, it seems. Let's see. Am I traveling that day? I don't think I'm traveling that day. Traveling the next day. All right. Go us. I'm going to
Mr.
wait.
Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
I'm going to wait because
Sign that, and I
this court has been very much one more thing.
will endorse it.
No, Stina G, this judge does not rule from the bench on just about anything. Yes, the camera panning is a lot. So, like a lot. We'll talk about the protective order in just a
Anything
minute.
else?
No, thank you, Your Honor.
All right, thank you, and I appreciate counsel and the third-party record holders coming in today.
12/12, 9 a.m. All rise for the court, please.
Ugh. 12:12 at 9 a.m. I guess we'll all be here early together. That's going to be a long day. All right. And everybody is shuffling out of the courtroom. We will be back in court December 12th at 9 a.m. Eastern for a Daubert hearing. There will be some expert testimony that day, I am sure. The court staff is allowing out the victim's side of the courtroom, and then they'll let out the defendant's side of the courtroom. And I will do a summary of what's happened today, and then we'll get to Q&A. And then, well, you all get back to doing all the things that you need to do in a holiday week, myself included. Laundry is the top of that list. I'm still unsure if I remembered to move something to the dryer last night. I have a sinking suspicion that I did not. But I woke up late this morning because I thought court was at 10, and it is, just not in my time zone. So all of that we will be getting to. But I captured a lot of your questions, so we've got time. Let's see. But I also do enjoy watching everyone shuffle out of court. So it seems that we've got another few moments of watching everybody shuffle out of court. The closed captioning is picking stuff up, but how accurate the auto closed captioning is, who knows? The camera went a long way to zoom in on literally everything. So, all right, lots of legally legal going on today. And don't forget, tomorrow there will be a podcast episode. I'll be in the chat with you. It's going to end up being longer than I anticipated because I, got lost in the sauce. I'm like, oh, I'll summarize this. And I'm like, oh, but then this. Oh, but then that. Oh, but this other thing. Oh, but then this other thing. Oh, but why don't I just tell you everything? So it intended to be shorter than it actually was. So tomorrow there will be a Emily Show podcast for you. We are counting down until we shift just to the Monday show. Don't forget, as we watch everybody shuffle out of court, there are a few things left in Lawnard Shop 2.0. So if you are loving the patch on the hat or the patch on the hoodie, we've got all of our new Lawnard Shop gear. Yes, some of it sold out faster than we anticipated, but it keeps us in the know of what you want for next launches coming in the new year. So we have lots planned for you in Lawnard Shop 2.0, but don't forget to head over to lawnardshop.com. If you're in the app, it's one of the ways to stay in the loop. Our members, of course, have early access. Those of you that are getting your orders in the next day or two from our members only early launch, those are the first orders that were shipped out. You will be getting your gift with purchase. I can't wait to see how you enjoy it. I can't wait. So for all of you that have not checked it out, be sure to check it out if there's anything you want. There will be launches coming in the new year. Don't worry. A lot of this, when it sells out, it is gone. For those of you that have asked about international shipping, we are working on it, but everything does currently ship out of the United States, which can make it a little bit spicy depending on where in the world you live. But we are always looking for ways to accommodate our international lawnards as well, while also making sure that we are providing you with the consistency and the experience that we very much value, and making sure that the goods that you are getting are consistent no matter where in the world you live. So thank you for checking out the Lawnard Shop over at lawnardshop.com and the Lawnard app at lawnardapp.com. You guys are the best. All right, let us get into all of the things. So Patty orders are shipping out. We have shipped lots and lots of orders. So you will get emails updating you with all of that. So do not worry. You will get the information. It's been a difficult shipping season. I don't know if you've seen some of that around the internet. I have had 2 advent calendars lost in shipping. It's been a difficult shipping season. But I'm very optimistic that all of our goods will get to you without issue. And if not, the website has a contact area so we can take care of that too. So don't forget, go to the Lawnard Shop to check out the contact. If you have any questions, it's on there. So for those of you that did not order during the members only, they might not have shipped yet, but you will start seeing the first orders being received today. So yes, I am wearing all of our new Lawnard merch. Yes, we custom dyed all the strings on the hoodies. Yes, they are as soft as can be. Let's try to do a summary of what happened in court today, shall we? Amanda the Witch on this said, I had a package shipped to a customer 4 hours away that took 12 days for UPS to deliver. It's been tough. And yes, there is a post-strike in Canada. It's been tough. It's been tough. The thing that is difficult for me is that there are many things in this process outside of my control. And I find that deeply frustrating because I just can't control everything. I know the Taurus with ADHD is like, the thing I struggle with the most is control. I'm sure all of you are shocked. So, I can't wait to see you guys get all of your Lawnard merch and the surprise and delight with our gift with purchase. I can't wait for you to see it. Let's do a summary. Let's get into Q&A. It's the holidays. And I am ready to, well, here's what I'm going to do the rest of the day. Get things ready so that my husband and I can go out early. I am often running late. I was running late when we went to the Creed show. And then I was like internally having a moment about it, because when you are neurospicy and time is a construct, running late is deeply frustrating. But we have an early dinner reservation tonight. We're going to go see Jelly Roll here in Nashville. I'm very, very excited. Tony is like, I am waiting for more black merch. I don't wear colors. I get it. The number one feedback we got after having 98.9% black merch for like 4 years was, we need merch that is not just in black. We have some other options. So don't worry. We are going to keep a balance of keeping it in the all black everything. And also for those of you that are like, girl, we can't just do all black everything. We will have variety. So I am very excited to head to see Jelly Roll. It is the first time I have seen him live in concert. And so I'm very excited to concert this evening with Dr. B and head out to dinner. I will share some behind the scenes to that, and we will get there. Do not worry, Claire. We will have some updated versions of our favorites down the road. K-Wag said, oh my God, saw Jelly and Jax on Saturday. Such a good show. Can't wait. I can't wait. I can't wait. I just saw somebody say that they just bought what I was wearing. There you go. Kathy at Oz is like, bought the one EDB has on. Can't wait. It's comfy. It's soft. And yes, a variety of options. And I don't have it in here with me because it's probably waiting to get clean. The hoodie I'm wearing in the podcast for tomorrow is like a dark heathered navy. I love it as well. So if you are looking for an in-between, for those of you who are like, no, I want everything to just be black, paint it black, motherfucker, let's go. That is the darkest color that we have for the hoodies this launch. Don't worry, there are more. All right, let us get to the recap, shall we? Let us recap the best. Well, my brain is like, everything happened. Everything happened. Oh, that was very quiet. Hold on, let's do that again. The swoop did not get its proper audio on my end. Today, we were back in court for discovery hearings in the Karen Reed case ahead of the retrial that is still scheduled for the end of January. Why? Because the court still has the motion to continue under advisement. At this point, I think that the court is keeping that under advisement to try to push the attorneys to get stuff done. Have you ever noticed that sometimes when you have more time, a task sort of expands to take the amount of time that you actually have? I wonder if part of the reason the court is keeping this under advisement is to push particularly the prosecutor to get things done in a timely fashion. It actually might benefit the defense to go to trial faster because it's going to cut off some of the discovery that the prosecution is now seeking. Oh, excuse me. That were subjects of the motion in court today. And that includes motions to the media. The prosecution has brought a number of subpoenas to the media, and this media has objected, seeking the unaired footage or the raw footage, notes, audio, anything else from interviews with Karen Reed and interviews with Karen Reed's father. One of those motions is regarding Boston Magazine and Gretchen Voss, but another one of those motions deals with ABC in that 2020 interview. The ABC part of this is a little bit differently situated because they are a New York-based company, and New York has reporter shield laws that do not exist in Massachusetts. So the media is arguing, look, the way that this has been interpreted by statute for and by the Supreme Judicial Court here in Massachusetts is that if you are subpoenaing an out-of-state witness, you need to go to their state and abide by their laws. And that extends not just to subpoenaing a witness out of state to come into court, but subpoenaing documents out of state to come into court in a criminal proceeding. So we will see what the court does with these motions. I think it is likely that the unredacted footage from the Gretchen Voss interview with Boston Magazine might be turned over. The prosecution has indicated that they think Gretchen Voss will be a witness in the case. But with regard to 2020, we might see a different response. We also heard a lot of discovery motions with regard to whether or not the prosecution will be able to get phone records from the defendant's mother's and father's phone. The prosecution arguing that the defendant called her parents at 1:30 in the morning on January 30th. The defense saying, no, there was only one phone call and it was at 6:30 in the morning. And all of this ties into the prosecution stating that they are going to be calling Karen Reed's father to the stand to ask him about the things Karen Reed said to him when she was speaking to him in the morning hours of January 30th. So it looks like the prosecution is going to be bringing a different trial forward using more of the defendant's own statements to try to prove their case. And that might include calling members of the media and members of Karen Reed's family. Yes, on a retrial, they can present different evidence. They can leave out evidence. They can present it in a different way. It is their choice. Of course, anything they don't bring in their case in chief, the defense can bring in their case, but the prosecution has the opportunity to really narrow down this case and bring in an entirely different set of witnesses. So we'll see if they do that here. We also saw the defense at the end as they were going through housekeeping saying that the prosecution is now going through elected DA Michael Morrissey's phones to try to see if there were ex-parte communications between the elected DA and judges regarding this case, and that the way that they were searching it, the defense wants to expand it. The court said, I need you and the prosecution to talk about this. And if you need to bring it up further, we'll bring it up December 12th. There's also discussion of a protective order. That protective order meaning that anything turned over to the defense with regard to the discovery the prosecution's turning over can only go to the defense team and the defendant and not anyone outside of the defense team. So there is quite a lot going on in this case. And it is speeding towards trial right now on January 27th. So we'll see what happens or if this gets put over till April. The court, of course, took everything under advisement, so we will see rulings down the road. Will we see rulings before the December 12th date? I don't know if we will. And we are also still hearing that the prosecution is doing the chip on to try to get more information out of Karen Reed's Lexus. And the defense indicated, and the chat reminded me of this, the defense indicated that DA Morrissey's phone is set to auto delete text messages every 30 days. Even if they come off of the phone, those might still be on the phone carrier end, but those are additional motions that would need to be made to go and get to the phone records from the cell phone provider, which is different. So there's a lot more to happen in this case before it goes to trial. And I think when it does go to retrial, we're going to see an entirely different case. Now I'm waiting to see when the Supreme Judicial Court is going to rule and what they are going to do with that question of double jeopardy. We will see. Let's get to your questions. I know you have them. I can't wait. So you've got questions. I've got questions. We've all got questions at this point. Let's just chat. Don't we just all have questions at this point? I think so. I've got to change the screen because it is just horribly distracting. All right. The end screen of the media was 100% distracting me. All right. Let's get to Q&A and some of our member chats and super chats and gifted memberships and all of the law nerd love and amazingness. N7 Cubone said it's my 30th birthday and happy to spend it with the law nerds. Cheers and happy birthday. I think there were a number of birthdays in the chat. So happy birthday to all of you. Christy said happy Thanksgiving week, travel and safe dinner topics. Oh, see, it's so easy when you don't live anywhere where you are traveling. That is a massive bird. I am not traveling over Thanksgiving. So for our family, or for my immediate family, it is very easy because it is me, B, and the boys. So we get to hang out. We're going to go to the movies. We're going to make dinner. We make what the kids vote on. We are doing tomahawk steaks this Thanksgiving with potatoes and stuffing and sides and all the things. Because you know what? We get to just do what we want. And we get to have a little bit of a slow Thanksgiving because there was definitely no time to travel this year. And traveling this time of year is a challenge, especially when it's not just an easy drive. So we get to just hang out. Laura, happy 19 month. Good to see all of the law nerds. B2, thank you for all the gifted memberships today. All the law nerds who are new are going to get to experience E and Dr. B streaming on Friday. Don't worry, I'll share in the chat what time we're going to do that. I have not had a chance to talk to him about it yet. Ready to get my law nerd gear delivery Friday. So exciting. Miss Tanisha, good to see you. I just turned 27 on the 22nd. So happy to be here. Happy birthday for all of you. Cumulus Cloud celebrated my birthday on Friday. Happy to be here. Good to see you. And again, we were going to be off all week. And then the court's like, nah, we're having hearings. And we're like, all right, well, I guess we're having hearings. Kimberly said, good morning and happy almost Thanksgiving. Thanks for this community and everything that makes it happen. A huge thank you to Team Baker on that and to all of you. This community happens because of the law nerds. That is a huge part of what makes all of this work. Michelle, thank you so much. It's good to see you. Rotten Ralph said I did the Avon walk for breast cancer in Boston. Amazing. Ashley's having coffee in California. Carrie in the chat said, hey, EDB, hoping to celebrate an achievement. Amazing. Let's do. My 9-year-old daughter and I qualified and are both competing in the Australian National Championships for ballroom dancing next week. Congratulations. Could you please wish us luck? Oh, Carrie, you've absolutely got this. I will wish you luck because you asked, but you guys have this. Have an amazing and beautiful competition. May all of the sparkles shine bright. May you be light on your feet and may everything be as amazing as all of the footage going around of Julianne Hough dancing to Looking for a Man in Finance on Dancing with the Stars. Absolutely amazing. So have the best competition. Have a lot of fun. And hopefully it is fun. Meow said, thank you for the amazing stream. You're welcome. It's my birthday today. Look at all of you. The first since losing my dad. Those are hard milestones to esophageal cancer. Thank you for keeping me company. You're welcome. Those are very difficult milestones. And I know that the holiday season can bring up a lot of those milestones when this year is substantially different than last year. I absolutely get it. Katrina Bunny said, Lally looks like me. He was told he can't mention the high top tables or snow today. Yeah, Lally is sitting there like, I will not say snowing. I will not say it's snowing. I will not say it's snowing. Indigo said, love a court stream. Me too. Kate said, good afternoon, EDB. I'm drinking lime squash. I have no idea what that is, but it sounds great. From my Lawnard cup with Pawnards in southern UK. I mean, I love all things lime, truly. Truly. Daniel said, I'm in the hospital this week with a leg infection. I'm so sorry. Thank you for being here to distract me from this bed. Oh, don't worry. We've got a long podcast for you tomorrow. We had quick bits dropping on Monday. We've got lots of things. Lots of things. Please no court in December, going on my first cruise. Robin Lynn, I am sorry, there will be court in December. We have lots of court actually in December. So I am apologizing in advance. Carol's dark sarcasm. It's the best kind of sarcasm. Are we confident it was snowing? Yes, at this point, I am confident that it was snowing. Charmander, we did hear a bit about the additional lawyer to the team. That will be granted. The court was just like, I have to ask about the Pro Hoc Vice. Botanist Gaming said, Bev, being so anti-asking the jurors, but being so okay to try to dig into defense strategy in open court has full sent me this morning. I understand with the request for the jurors, it is a fine line. But yes, also, Pro Hoc Vices are normally just granted. Like, why do we need to know? Why do we need to know? Love watching you, EDB. The mods are great. Yes, thank you to the mods for being here today and for all of Team Baker. Let's see. Gino asked, EDB, does this mean they will call Karen Reed's dad? It means they're preparing to call Karen Reed's dad. That's what it seems that they are preparing to call Karen Reed's dad. I talked about that earlier on in the video. That might backfire spectacularly. Lily E said, have you heard about the case in Kentucky where the sheriff shot the judge in the courthouse? I have heard about it. It is on my docket to look into as some of the cases that I am covering slow down a bit. Because look, it took me, I don't even know how many hours to read through all of the motions in Idaho to try to distill them. It's been incredibly busy and I have a lot of questions about that case, but it is on my radar. But there is not much for me to cover yet because we don't know. Emma Meg said, why can't they just subpoena the records? They did subpoena the records. There were objections to those subpoenas, and therefore we are at discovery motions. Kat Q said, EDB, I get that there are no shield laws in Massachusetts, but where were those interviews? Why were those interviews? Oh no, were those interviews conducted there? It seems so. If so, would the journalist be covered by the laws where they had the interview? It really depends on where the company is. And we heard some of those choice of law and some of those argument about the laws later. Cindy said they want the parents out of the courtroom during trial. I don't know if that will work, because even if the parents are witnesses, they were there during the first trial, they'll be allowed to be there during the second trial. So, let's see. Anon Mouse said, so if you do decide to do an interview, for goodness sakes, take it out of state. That might not work depending on where the company is. Kelly said, what if it's private information about her medical conditions? If she's telling it to a reporter, it's not going to be considered private for this context to be discovered. That doesn't mean it will come in trial, but that's not the consideration when deciding whether it gets turned over or not. If it's private, then don't tell a reporter. B2 gifted another 20 memberships. Thank you. Kelsey said, looking cozy and cute. I appreciate the compliment because I feel like I am looking tired this morning. So thank you. But I am also, that's completely my own fault. Could the judge have ordered a gag order? The judge could, telling Karen Reed that she can't speak about the case in light of the First Amendment would have been incredibly difficult. So Karen Reed has a right to remain silent. If you choose not to remain silent, that can and will be used against you, and that's where we are. So the judge issuing a gag order wouldn't have really helped with that, because it would normally apply to the lawyers. It's hard. Yeah, let's unpack that. Said, how is this not a violation of your constitutional rights, free speech, media, etc.? Well, she has the right to speak, but the government has the right to discover it because it was not a privileged conversation. And Massachusetts gets to have their own laws on how they interact with the media. Different states do it differently. So that's a little bit different. Amy said, took a respectful drive down 34 Fairview. The yard is so small and close to the road, improbable that they walked to their cars and didn't see him, blew my mind. And that is part of why the jury did a jury view, so they had a sense for the yard and how big the yard was. What about under oath versus public chats? That's something that gets argued as to the weight of what was said. So the defense will argue down the road, if these statements come in, look, she was talking to the media. But we'll see. Back in Massachusetts, we live here now. We do. It's going to get cold and snowy. Are they recharging on all charges? They are retrying Karen Reed on all 3 charges at this point. Kathleen said, can the father plead the 5th? Can the father say, I will not speak to you and I plead the 5th? I mean, he can refuse to answer questions and get held in contempt, but he doesn't have a 5th Amendment privilege unless he is at risk for being charged with something. So I don't want to assume that he did anything that he would be charged for, but would he probably have to seek an attorney to try to assert some of that? Probably. I saw a great question in the chat real quick. I don't know if I'm going to be able to grab it, but Richard Tinsley said, can this judge overrule New York judges? No, not with regard to New York laws and New York subpoenas. This judge could try to issue a subpoena and the judge in New York can go lol and just quash it. So no, they can't. Silver said, I just got a notification my PIN will be here Friday. Exciting. Elizabeth said, does the state get to introduce new evidence? I thought they had to work with what came from the first trial. Nope. They can continue to develop their case. They can seek new evidence. They can bring new evidence in. They can leave evidence out. It is a new trial and they get to start fresh. So they can do what they want. Let's see. Banjo Bones Mama said, I'm about to plead not guilty for driving with a suspended registration because the PA Turnpike neglected to update my information. I'm sorry. But if it wasn't suspended, then that shouldn't be on you. Nor said petition for an EDB pool camera. Gosh, look, if we get to a point where we have the money to run our own pool cameras, won't it be lovely? Noel said, can her not giving delay when both parties ask to be put up on appeal if she gets convicted? It won't go very far, but yes, it's something that can be brought up, but this happened in the first trial as well. So yes, it will be brought up. Will it be persuasive? No, it's within the judge's discretion and they knew. And at the time they set the date in January, the attorneys didn't say, no, we need to set it out further. So that would be a hard one to argue. Let's see. Reximoto said, do we know if they are done with the federal investigation and trial? There hasn't been a trial in the federal investigation. There hasn't been any charges. I don't know if they're done with the grand jury or not because we just don't know. So we will see. Casey Cat said, just got my first of 3 Law Nerd Shop 2.0 orders 5 minutes ago. The gifts are awesome. I'm so glad. Casey Cat, I'm glad you enjoy them. Yay. Megan McCabe said, Emily and family, happy Thanksgiving. What's your favorite Thanksgiving food? I talk about that tomorrow at the end of the podcast. I'm going to leave that for tomorrow at the end of the podcast. So join me tomorrow. Join me tomorrow for the podcast and we'll go from there. Jen K said, happy Thanksgiving to all who celebrate. Thank you, Jen. KO, I saw a chat in the chat. We, if you sent an email, we always hold some back in case things arrive broken. So we will see what we can do. So yes, we always hold some back in case things arrive broken. JJ with the dog said, thanks for normalizing immediate family only for the holidays. I don't have much extended family left and it's hard sometimes. It can be hard. I really find a lot of coziness in spending the time together with family. Of course, there are times I miss bigger Thanksgivings and we have, like, our holidays have looked so different in all different phases of life, but we really do treat it as cozy and it is much lower stress than trying to drive all over everywhere. But there are definitely times when I see people having large Friendsgivings and stuff and I'm like, that looks like so much fun. Here's the truth. This is just the truthy truth. It looks like so much fun. If I had to prep meals and like get dressed and do multiple Friendsgivings, I would probably have the worst anxiety. I am always a little bit tired this time of year, and I want to be at home with a blanket. And in my brain, I'm like, that looks fun. And then in my soul, I'm like, I don't want to leave the house. So I absolutely get it. But we treat it as a cozy time of year and see family at other times of year. So that is what we do. But we do immediate family, and it's something I really enjoy with the kids. And we see family at times of year when travel is not quite so difficult and when court is not quite so busy. So there's that. Mama Bear of One said, my daughter turned 18 Monday and we're taking her to a Ren Fair Sunday to celebrate with her two friends. That sounds like so much fun. Where is there a Ren Fair this time of year? That sounds amazing. Let's see. Izzy Sand said, hi, my 10-year-old son and I are watching you right now. He asked, how do you know when a witness is lying? Can you please give Guillermo, my son, a shout out? Hi, Guillermo. How do you know when a witness is lying? Sometimes it's hard. Sometimes you can tell. Sometimes it takes just knowing what they've said before and asking good questions and seeing if those questions fall apart. Sometimes when people are questioned when they're lying, they get really mad, and you can see that on the stand if they get really mad, but you really have to rely on a good examination or good cross-examination, and that's what cross-examination is for. Being curious and keep asking the next logical question. It's very much like what we do when we were a kid. It's like, we can't do this. Well, why? Well, because of this. Yeah, but why? Well, because of this. Okay, but why? And you just keep going until you get to an answer that either makes sense or doesn't make sense. But sometimes you can tell in the way people act and the way that they talk. Devin said, did you see the Vanderpump Rules news? The only news that I have seen is regarding Schwartz and Sandy's closing, and I'm not surprised by that. What I want to see is the reaction to that from Katie and from Ariana, but it seems like Schwartz and Sandy's took a toll on Katie, and Schwartz is married. So let's see. You guys are saying they're recasting it? Show is canceled. That I had not seen. That's gonna be a problem. The cast is not going to be happy at all. So I saw a question: when will the next merch launch be in the new year? Katie was right. The name was stupid. Tony. You're right. It was. You're right. It was. Music to My Soul said, would there be any valid reason for a judge to deny the request to add an attorney? I guess there must be theoretically be one, since she didn't rule yet. She's going to grant it. And, God, I would have to think of a hypothetical. I mean, maybe if they were asking to add an attorney who was not in good standing. I mean, you can't add an attorney who's not in good standing with the bar in their own jurisdiction. So an attorney that was not actively licensed or who was having a lot of disciplinary issues. So that would be it. But the court's going to grant this. And some of you are saying it's already been granted. Yeah. So that. Checking in with baby Leonard, who is 8 months. The Danish doll, congratulations. I hope it is sweet and nice, happy, cuddly time this time of year. It's lovely. It's lovely as they get older. Look, all phases of being a parent have different and unique benefits and challenges, but it is the snuggly sweet littleness is just so sweet. However, I'm living for teenage snarky memes. Oh my God, you guys, can I tell you a story? I'm gonna tell you a story, and then we're gonna get back to Q&A. I'm gonna tell you a Griffin story. Griffin and I were in the car going to school. Griffin loves Weird Al. Loves Weird Al. Loves. He doesn't know he's getting Weird Al tickets for Christmas because Weird Al is playing in Nashville. Look, at this point, Emily, what do you spend your money on? Concert tickets. I spend money on concert tickets. Griffin's sense of humor is a neurospicy, direct, sometimes cutting, not always intentionally, just a very astute perception of the world. So we're listening to one of his favorite songs, Albuquerque, And in listening to Albuquerque, there is a moment in this very long storytelling process where Weird Al is talking about getting onto a real plane. Like, it's my first time on a real plane. So I asked Griffin, hey, does the fact that he's talking about this as his first time on a real plane imply that maybe there is in fact a fake plane? And if there is a fake plane, what would that even look like? Like, what is a fake plane if he's on a real plane for the first time? Do you know what my kid says from the back seat? Because he refuses to ride in the front seat, even though he's old enough and big enough. Do you know what this child, without a second pause, without a second fucking pause, as I say, what would a fake plane be? Do you know what he says? Spirit. That's what he said. That's what he said. I'm like, I am dying. I am dying. I am dying. What would a fake plane be? Spirit. Griffin. A, why do you even know? B, I mean, not wrong, but my 12-year-old is just like, Spirit, obviously. Anyway, brutal, hilarious, but that was his recitation of Spirit. Spirit Airlines is Griffin's opinion on what in fact is a fake plane. So I absolutely died. I laughed for way too long because it was just like, boom, roasted. And there are times I'm like, how do you even know that? Like, what have you seen on YouTube is really the question. And then Brian and I were talking, and they listened to a news podcast every morning, and they had just been talking about Spirit maybe filing for bankruptcy or something. So all of it, for sure. Dave Neal just broke the Vanderpump Rules news. I mean, if it just broke, I've been watching court. I don't monitor the news when I'm watching court. Let's see. Can I even? All right. Well, new cast for Vanderpump Rules. They tried that before. It didn't go well. I don't know. Is it better to keep the same IP? Or is it better to just, oh yeah, an hour ago. We were in court an hour ago, everybody. It's just breaking. It literally just breaking. Vanity Fair published 18 minutes ago, page 6 posted 54 minutes ago. This is like breaking news. When we say no breaking news in the chat, that we've violated all of our own rules to talk about reality, which is fine, because it's at the end of the day and it's not heavy information to process. A lot of the time, breaking news can be very heavy to process. I don't know. What do you guys think in the chat? Are you guys like, yeah, that tracks, it's fair? Like, is it just time? Let's see what Us Weekly has to say real quick. Why not? I mean, why not? Let's see. We love the reality. I know a lot of you are like, Emily, I found you talking about pop culture, and now everything we've been talking about has been very murdery, and it's way too heavy, and we don't get to talk about reality anymore. I know. This just does not want to pull up on screen. How did I end up on some kind of wild advertisement? Give me 1 second. My computer is being spicy. I need a new window. All right. Let's see what the publications have to say. There we go. I don't know. Do we need a new cast? I don't know. Do we? Oh my God, there are so many ads. Yeah, I understand that life is expensive, but do I have a reader mode on this thing? No. Let's just look real quick. Do I care? No, it's fine. Let's see. This is coming from what? Us Weekly. Real quick. No reader mode. All of the ads. Bravo is bringing Vanderpump Rules back for another season, but with a major cast overhaul. The network announced Tuesday, November 26th that season 12 will feature Lisa Vanderpump and a new group of close-knit servers who are as complicatedly involved with one another as their iconic predecessors. The new season begins production next year and will premiere to be announced later. What a thrill it is to build on the legacy of this series by doing it all over again. Do we need to? Like, why are we just, why? Why are we not just creating new IP? But okay, probably because there's still money to be had in this IP. With profound appreciation for the original group and their iconic run, we can't wait for the audience to see a dynamic new group of coworkers and friends make their way through life together. Vanderpump Rules, which debuted in 2013 as a spin-off, evolved into its own franchise. The show originally followed, we know, oh good God, I can't even. We know how it evolved. All right, well, moving on. Who on the cast is most upset about this? Who's the most mad? Sandoval? Schwartz? Who's the most mad? Sheena? You let me know. You let me know in the chat who's the most mad that Vanderpump is moving on. So, you let me know. All right, I'm going to do a few more questions and then we're going to go. Let's see. Fiona said, happy to be here on my birthday. Just found out I'm going to be a grandma for the first time in May. Fiona, congratulations. May is a great month, though I am very much a Taurus, so I am very biased to May birthdays and somewhat biased towards May Tauruses. Emily, yes, that makes so much sense. Creekside Casual says Ponard is sitting this today, and I'm looking forward to binging back-to-back episodes. Happy Turkey Day, everybody. All right, Chris sent me a link. Oh, from Bravo. Oh, the Bravo announcement. Well, if I return, did they announce it at FanFest? It looks like they did. Thanks, Chris, for the Bravo announcement. They made the announcement that they are starting over. Thanks, lady. I appreciate it. So, I mean, okay. Everybody's going to be mad. Sandoval's going to be mad. Sheena's going to be mad. They're going to be mad. All right. With all of that, Law Nerds, I think we answered all of the legal questions. We galloped away into a little bit of pop culture and stories. I think that's absolutely okay. It is that time of year that we need a little bit more pop culture and a little bit more little less serious cases. So it's so many. Emily, are you going to see Wicked? It's amazing. Yes, we will be going to see Wicked. As a entire family, I have been advised to bring Kleenex. I mean, I cry at commercials, so there's that. But have not seen it yet. Look forward to going to see it. And yeah, the family is going to go see it. I love getting to go see the movies. So we will just decide when we are going to see it, but we'll go see it sometime this week. So for the rest of the week, tomorrow, Emily, you wanted an entire week off. Yes. Tomorrow there is a new Emily show, Wednesday show dropping. I go over what's going on in Idaho, the Diddy stuff, and a few quick updates. So that's tomorrow. If you want to hear about all of the Diddy on Diddy and see me go, oh, more Diddy. Great. So that's tomorrow. I'll be in the chat with you. If you just want to come and chat, just come chat. I'll see you tomorrow. If you want to pop it in the background while you're cooking, I'm sure it's going to be over an hour. We'll see. Then on Friday, we're going to have a members only in the evening. I don't think too late. Dr. B and I are going to confirm a time, but I will share with that in all of the spaces. Hen House Bathco, thank you for reminding me. I've been wanting to do this too and buy tickets for Trans-Siberian Orchestra. So thank you. I want to go see them too. Look, go to the concert. Life is short. I know they're expensive, but the sound is great no matter where you sit. And the experiences are absolutely worth it. And it is my favorite thing to do. I hear my family just getting home, so I'm going to go see them. For those of you asking about the nails, yes, we did a little bit of a maroon cat eye with some glitter and something. Like, we just did all the things. It was like, Emily, can you decide? No. So we get 3 manicures in one. So that's what we did. All right. I am going to concert this evening. Members, I will see you live on Friday. Everyone else, I will see you in the chat tomorrow. And then as we get into the first week of December, I can't believe I'm already saying that. Because where did this year go? Oh, finally, I just opened my Google Calendar to tell you what our next court date was. And it finally has the option for a dark mode. Well, thank fucking God, it's about time. On December 2nd, we will be back for Sarah Boone's sentencing. So if you are ready to go back to live court, we will be back December 2nd for the sentencing in Sarah Boone. The prosecution has not responded to our motion for new trial. We have not seen a single sentencing memorandum, but it looks like the sentencing evaluation has been completed and that has been filed under seal. So we will be back Monday, December 2nd, with the sentencing on Sarah Boone. It looks like the jury is deliberating in the remaining defendants on the YSL case. So that is there. For any of you that are like, Emily, I'm missing some of your coverage. You keep talking about other things that you've done on Quick Bits. Don't forget the Quick Bits is a separate channel over here on the YouTube. So there are episodes that drop there. On Monday, it is an episode where I give you a summary of generally a number of different cases. And then we also have cut downs from the live stream and the summaries there so that you can stay in the loop even when you don't have time for the full stream, or when there's cases on stream that you're like, that one's not for me, but I want to know about this. So I will be back in court with you on Monday. Take care of yourselves, take care of each other, have fun. Law nerds, you're the best, and I will see you soon. Have a good one, you guys, and I will show you, I will do some of the behind the scenes stuff in our members only from the concert tonight, as we always do, because then we can deal with it in the best way possible when we are in the members only spaces. So take care, and I'll see you soon. Bye, guys.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.